Hello and welcome to this module on plea bargaining. I am Preeti Lakhera, Assistant Professor Law, National Law University, Delhi. Today I am going to make a presentation on the module for plea bargaining in this e-Pathshala initiative. Now I am going to start with giving an overview of the module I am going to present. We are going to focus on the problems of the criminal justice system, the legislative framework for plea bargaining in India, the application of the legislative framework in India, and the merits and demerits of the system of plea bargaining procedure. Now primarily the objectives of any criminal justice system is to give a redressal mechanism when the rights of an individual are violated by another individual. Now the criminal justice system criminalizes various actions and prosecutes the accused who is charged with violating those rights of the other individual. But at the same time, in this endeavor, where you are trying to give one-stop mechanism of redressal for the accused person, you are basically creating a situation where the state and the accused are standing on an unequal platform because of the mighty power of the state. So it becomes very important that at every step of this trial procedure, the rights of the accused are guaranteed by giving him a right to a fair trial. Now in this endeavor to make the system very fair for the accused, we also make the trial procedure very slow, cumbersome and very expensive. The result is a large number of pendency of cases in various criminal courts across India, and obviously the resultant under trials who are waiting the final outcome of their cases. Now it is in this background which it becomes imperative that alternate dispute resolution mechanisms like plea bargaining have to be created. Now let me come to the learning outcomes of my module. Now after introducing the legislative framework of plea bargaining in India, we are going to talk about the types of plea bargaining, the merits and demerits of this scheme, and also understand the administration of plea bargaining in India. Now I am going to start with some basic definitions. Now Wikipedia defines the term as a plea bargain is an agreement in a criminal case in which a prosecutor and a defendant arrange to settle the case against the defendant. The defendant agrees to plead guilty or no contest in exchange for some agreement from the prosecutor as to the punishment. A plea bargain can also include the prosecutor agreeing to charge a lesser crime, that is also called reducing the charges, and dismissing some of the charges against the defendant. The Black's Law Dictionary defines plea bargaining as a negotiated agreement between a prosecutor and a criminal defendant, whereby the defendant pleads guilty to a lesser offence or to one of the multiple charges in exchange for some concession by the prosecutor, usually a more lenient sentence or a dismissal of the negotiated charges. So basically plea bargaining is like a pre-trial settlement between the accused and the state, where in consideration of his cooperation we are either mitigating his sentence or reducing his charges. Now coming to the various types of plea bargaining. The most famous are charge and sentence bargaining. Now in charge bargaining, the promise is that in exchange of his guilty plea, we are going to reduce his charges to a lesser degree. In sentence bargaining, as a promise from the state, a more lenient sentence will be given to the accused if he agrees to plead guilty. Now on the same lines, fact bargaining says that as a promise in consideration of his guilty plea, the prosecutor will not prove the aggravated facts against the accused in the case and also will not contest his version of the factual situation. Now obviously this is going to help the accused when the sentencing comes into the picture. There is another characterization of plea bargaining which we call as implicit and explicit plea bargaining. Now, in explicit plea bargaining, they are face-to-face negotiations between the prosecutor and the accused, where the accused is promised what will be the final outcome of the case in case he agrees to plead guilty in the case. In implicit bargaining, there is no face-to-face negotiations, but there is an implicit understanding which is created by a practice of the trial court judges that the people who participate or cooperate in pleading guilty will be given some concessions at the time of the sentencing. Now, I am coming to the introduction of plea bargaining in India. Now, the initial approach of the Indian judiciary towards plea bargaining was quite hostile, because in a way plea bargaining is an alternative procedure which circumvents the right to fair trial of the accused person. So, you have a line of Supreme Court judgments from Murlidhar Meghraj Loya to Kachi Patel Shantilal to state of Uttar Pradesh versus Chandrika, to name a few, where the Supreme Court has clearly said that this scheme and this procedure is just not part of the Indian system. But then you see a softening of their stand, and just to take a lines from a very famous Gujarat High Court judgment, State of Gujarat versus Natwar Harchandji Thakur, which very quietly sums up the very object of law is to provide easy, cheap and expeditious justice by resolution of disputes, including the trial of criminal cases, and considering the present realistic profile of the pendency and delay in disposal in the administration of law and justice, fundamental reforms are inevitable. They should not be anything static. It can thus be said that plea bargaining is really a measure and redressal, and it shall add a new dimension in the realm of judicial reforms. Now, further, the Law Commission of India in 142nd and 154th report actually studied the challenges of the Indian criminal justice system. Then it also studied the jurisdictions which are existing across the world and how they are solving the problems, and came to the conclusion that plea bargaining can be used to solve the huge pendency of cases and to reduce the under trials in the jails. They recommended the introduction of plea bargaining in India, though with a caution that the scheme has to be introduced on an experimental basis only to a limited number of offences. The Malimat Committee on Criminal Justice Reform in the year 2003 reiterated the stand of the Law Commission. Thereby, by the Criminal Law Amendment Act of 2005, Chapter 21A was introduced in the Criminal Procedure Code of 1973, and sections 265A to 265L found their place in the Indian system. Now, I am going to briefly analyze the provisions section 265A to 265L, which are giving you the legislative framework of plea bargaining in India. Section 265A is talking about applicability. Now, it clearly tells you that this scheme will only be applicable to offences which are punishable with less than 7 years. Even within that, the offences which are against women and children or are characterized as socio-economic offences, the scheme will not be available. Section 265B is giving you the modalities of the application for plea bargaining. It tells you the application has to be accompanied with a brief description of the offence and an affidavit mentioning that the accused is participating in the procedure voluntarily and he has no previous conviction record for the offence. In addition to this, the scheme also directs the judicial officer that he has to call the accused person who has applied in person and confirm that he has applied voluntarily. In practical context, this is done by administering a structured questionnaire to the accused in camera. Now, this questionnaire tells the accused person that first of all, he has a right to fair trial, there is no compulsion to plea bargain, that if he exercises this option of plea bargaining, then he will lose many rights associated with the right to fair trial. He cannot confront the witnesses, he can lose his right to be convicted by proof beyond reasonable doubt. Also tells him that the judgment of the plea bargaining magistrate is going to be final except some room for appeal. So, all those possibilities which are going to come are communicated to the accused person with this questionnaire. Now, this application has to be filed before the magistrate where the case is pending for trial. It does not mention the duration up to which the accused person can file this application. Now, when the voluntariness of the accused satisfies the judicial officer, then he is going to give him time to work out a mutually satisfactory disposition of the case, which would involve giving compensation to the victim. Section 265C gives the guidelines for working out a mutually satisfactory disposition of the case. Now, first of all, notice has to be given to all the stakeholders. To mention specially, when the case has been instituted on a police report, the investigation officer, the public prosecutor, the accused, the victim, and they can also bring their lawyers, they have to be notified about the meeting to work out the mutually satisfactory disposition of the case. Further, there is a responsibility of the judicial officer that in the entire procedure, the voluntariness of the accused and the victim is guaranteed. How this has to be achieved, the legislature is not going to speak about that. Section 265 details that irrespective of the outcome of the meeting, whether it's a success or a failure, a report has to be filed before the concerned magistrate. 265E tells a situation where a scheme has been successfully implemented, that is, the mutually satisfactory disposition has been successfully worked out. Now, it gives directions for the final disposition of the case. Now, it is a very important provision because it is giving the sentencing guidelines to the judicial magistrate for a plea bargaining application in India. Now, in case there is a minimum punishment for the offence, he can give half of it. In case there is no minimum punishment, he can give 1/4 of it. He can also use the provisions of admonition under section 360 of the Criminal Procedure Code and also provisions for probation under the Probation of Offenders Act of 1958. 265G further tells that the judgment given by the plea bargaining magistrate is final and the only appeal can lie under Article 136 to the Supreme Court of India and under Article 226 and 227 of the Constitution of India. Section 265I mentions that whatever imprisonment has been undergone by the accused person can be set off by the sentence provided under this procedure. Now, this is remarkable because one of the main reasons of introducing this scheme was to reduce the under trials languishing in Indian jails. Section 265K says that any statements which are made during the procedure of plea bargaining, they will only be used for this procedure. They cannot be used in any other proceeding, even not in the case goes on to have a formal trial. Further, 265L makes the whole scheme not applicable to juvenile and children. Now, this is the legislative framework in Criminal Procedure Code. But apart from that, some practicing guidelines have been issued by some high courts across India. Like in the case of High Court of Delhi, its website gives you detailed guidelines regarding implementing the scheme in the various criminal courts of Delhi. A remarkable feature is that though the application is made before the court where the case is pending for trial, it is forwarded to a separate magistrate who is characterized as a plea bargaining magistrate for that case, and in case the application is not successful here, then the case again goes back to the initial magistrate. Now, this procedure helps to, you can say, save the possibility or avoid the possibility of any bias which might come in the mind of the formal trial magistrate in the event the plea bargaining is not successful. In India, the plea bargaining has been incorporated primarily from the United States of America jurisdiction. Giving you a brief idea about that system, it was in year 1970 in the landmark case of Brady versus United States that the American Supreme Court first of all accepted the constitutionality of plea bargaining. And it is Rule 11 of the Federal Rules of Criminal Procedure which lays down the legislative framework of plea bargaining in America at the federal level. Also, the federal sentencing guidelines create various levels of reduction in offences in case the defendant agrees to accept the responsibility of his actions. Now, in America, nearly 90% of the convictions are done through the route of plea bargaining. Now, I am going to briefly compare the administration of plea bargaining in India and USA. Now, the differences are, in America, the office of the prosecution holds immense relevance and inspires great confidence. So, basically at the pre-trial level only, the prosecutor can negotiate directly with the defendant and his lawyer and come out with a settlement, which can later be approved by the judicial officer. Now, in contrast to this, in the Indian scheme of affairs, the judicial officer is playing the central role. In America, there is a business-like approach in negotiations which guides the negotiations of plea bargaining. Now, because of that, there is a requirement on the part of the prosecutor that he has to reveal every detail about the case and the full evidence investigated on the case to the accused person, because bargaining has to be done on equal terms and conditions. Now, similar requirement is not there in the Indian context. America allows charge bargaining. So, as a promise to plead guilty, actually you can get your charges reduced. In India, only sentence bargaining is allowed, which means even if I plead guilty, I cannot say that dilute my charges. I will be framed against the same charges. The only relaxation is my sentence might get reduced. In America, most of the offences, barring some, are covered under the scheme of plea bargaining. In contrast to this, the Indian version is a very truncated one. The scheme is applicable only to a few offences. But apart from this, we have similarities also, as both the countries stress on the concept of due process of law, right of fair trial of the accused person. They make it a great requirement that participation in the scheme is voluntary on the part of the accused. Also, the accused is allowed that he can withdraw from the application at any stage of the case up to a certain level, so that if he wants to exercise his right to fair trial, he can do so. Also, any statements given by him during plea bargaining are never to be used against him. Now, let us do a little critical analysis of the existing scheme of plea bargaining as it is existing in India. Now, I am going to talk about some merits and some demerits of this procedure. Now, the merits are that it is an alternative to the formal trial, which is long, cumbersome, very expensive, and the Act is giving you enough safeguards by emphasizing on the voluntariness on the part of the accused person. There is an end of uncertainty from the point of view of the accused, because he can move on and start a new life. Further, there is a relaxation in sentencing, which is built in the sentence. So, if he pleads guilty, he can expect a less sentence from the court. Now, at times the accused is genuinely sorry, and this scheme allows a space where when the accused is sorry and when the victim willing to forgive, they can go for a settlement and the case can be over, thereby saving the time and resources of the judges and the criminal justice system in one go. Now, most importantly, the biggest merit of the scheme is the participation and compensation to the victim. So, it is giving a one big element of procedural justice to victim, who now actually gets to participate in working out the mutually satisfactory disposition of the case and can get compensation also from the accused person. But it has its demerits also. The biggest demerit being it compromises the right to fair trial. As the accused has been given this right, because the state is mighty and they are unequal, this right has great significance. Another problem is that the plea bargaining procedure labels the accused as a convict. Most of the offences which are plea bargained in India, they are also allowed to be compounded. Now, in the compounding of offences, the procedure is more quick because it is completed within the same court itself, in comparison to plea bargaining, where the application is filed in one court and it is heard in another court. So, basically the accused would always prefer the compounding of the offences. Also, in compounding of offences, the label of discharge is attached with the accused person. So, he is not called a convict. So, obviously he wants to choose compounding of the offence over plea bargaining of the offence. Next in line is that because of very inefficient investigation procedures, most of the evidence collected is quite weak. So, there is a possibility that the accused can actually get a discharge. No incentive to participate in plea bargaining then. The plea bargaining mechanism can only work when the evidence is so strong that the accused, when it looks at it, might feel that I might get convicted and get a big sentence in case I don't agree to plead guilty. Another reason why the scheme might fail is that after putting up the application, either the accused does not turn up for the mutually satisfactory disposition meeting, or the victim does not turn up for that meeting, and then things do not go forward. Also, like in the case of India, where various studies have proven that accused generally comes from such a socio-economic background that it is not possible for him to give any compensation to the victim. And in case no compensation is there, the possibility of arriving at a mutually satisfactory disposition gets closed, thereby leading to a failure of the plea bargaining application. Further, the legislative framework is not giving you any time frame within which the application has to be disposed of. Coming to the conclusion of this whole module, there is a dearth of authentic studies to tell us how this scheme has been functioning after it was incorporated in the year 2005. So, we do not have any data or good research material which tells us as to what is the experience of various stakeholders like the accused, victim, prosecutor, judicial magistrates, defense lawyers, investigating officers who actually use this procedure. The only data which is available is the data regarding the pendency of the plea bargaining applications when it is listed in the district courts of various courts across the country. Like the statistics available for Delhi tell us that till 30 July 2013, out of the 14,442 total cases filed for plea bargaining, only 7,884 have been settled. So, this is a data which is quite not updated. Further, there is a lack of reporting on case laws on plea bargaining which primarily functions at the lower court level. Now, Times of India has been one of the few newspapers to report a first case of plea bargaining around 2007, where it was a Reserve Bank of Indian official had applied for plea bargaining in a corruption case. Obviously, the application was refused as corruption was like a socio-economic offence. Further, in the case of Vijay Moses Das versus CBI, a 2006 judgment, the Uttarakhand High Court had directed the trial court judge to admit a plea bargaining application. Now, in that case, even when the CBI and the ONGC, which was the defendant, were not opposing the plea bargaining application, the trial court had rejected it. So, these are the some cases where we find the application of plea bargaining. Now, there has to be an urgency that if this criminal justice system shouldn't be collapsing under the huge areas of cases and the great under trials languishing in jails, that we should look at this alternative dispute resolution mechanisms in the realm of criminal procedure with more vigor. Obviously, plea bargaining is not the only answer. We have the compounding of offences. We had introduced the fast track courts for certain number of offences, but each and every procedure has to be utilized towards its full potential. Plea bargaining's biggest demerit lies in the fact that it compromises the fair trial to the accused person. So, though there is efficiency introduced in the system, it compromises on fairness. Now, this scheme is trying to balance this dichotomy between fairness and efficiency by creating safeguards at every level, from the requirement of the affidavit to the administration of a structured questionnaire to the accused person, to seeing that the victim gets compensation. So, there has to be a collective effort on the part of all the stakeholders, from the public prosecutor to the judicial magistrate to the defense lawyers to the counsels, to popularize the scheme among the accused person and the victim, so that the criminal cases can be disposed of without the requirement of a formal trial. Now, I am going to quickly summarize my module. Now, we just talked about that plea bargaining is like a pre-trial settlement. The legislative framework of plea bargaining is found in Chapter 21A of the Criminal Procedure Code 1973. The detailed procedure for the scheme is contained in sections 265A to 265L of the Criminal Procedure Code of 1973. Now, in the Indian realm of affairs, the central role has been given to the judicial officer. It is his office which is inspiring the maximum confidence in the criminal justice system. So, he is required to maintain the voluntariness on the part of the accused, to take into account the rights of the victim also, that he gets the due notice, he gets the due compensation. He is fully responsible for implementing the scheme. Further, sentence bargaining is allowed. Actually, section 265E is giving relaxation in the sentencing guidelines. Also, as a matter of practice, through the plea bargaining procedure, the judicial magistrates can actually make great use of the provisions of admonition under section 360 and the Probation of Offenders Act 1958 to see that unnecessarily people should not be languishing in jails, waiting for their trial to get over. Now, the scheme is good because this is available to the accused person only at his own option. So, there is no coercion on the part of anybody that he should take the scheme. The option is totally his. And for the first time, this is one procedural justice in the criminal justice system for the victim, where he is given participation about the outcome of the criminal case, and also a compensation is envisaged for him. Now, though this scheme has come from the American jurisdiction, I pointed out the notable differences also. The office of the prosecutor is not relevant that much in India. Charge bargaining, which is allowed in America, doesn't work under the Indian realm of affairs. Further, in America, it is a very widely used scheme. 90% of the offenses get plea bargain because the scheme is widely available across all the offenses. In comparison, India has only adopted a very truncated version. So that means for offenses less than 7 years, and even within that sphere, if it is against women and children, if it is a socio-economic offense, plea bargaining will not be allowed. Now, I told you there is a dearth of studies to study the impact of the scheme, though the scheme has been around from the year 2005. So, we need to do a lot of research as to the experience of the stakeholders of the scheme, as to what is the data on the cases which have successfully been converted into mutually satisfactory disposition, what has been the sentencing policy in the case of plea bargaining application. Has this actually reduced the under trials in the jails? Has it actually reduced the areas of criminal cases in Indian courts? Now, on a last note, the procedure, if it has to meet its true potential, has to be used on a wider scale, which can be done only when it is popularized into the masses who are actually going to use it. Now, only when the scheme is implemented and is in great success, reaching its true potential at its current scheme of affairs, then we can advocate its applicability to a more wide range of offenses. Thank you, and thank you for listening to this module.